The conservative majority Supreme Court appears ready to side with a Colorado web designer who does not want to create wedding websites for same-sex couples. Lorie Smith is her name. She argues her First Amendment right to free expression should allow her to refuse those couples. NBC News reports civil rights groups say that Smith is asking the court for a, quote, license to discriminate that would gut public accommodation laws that require businesses to serve all customers. Justice Sonia Sotomayor tried to clarify that point during her questioning.
How about people who don't believe in interracial marriage? Or about people who don't believe that disabled people should get married? Where's the line? I can choose not to sell to those people? This website? Because it's my speech?
Let's welcome Dahlia Lithwick, Slate senior editor and legal correspondent. She's also an MSNBC law and politics analyst and the very, very best at this topic. I'm so glad you're with us tonight. What did you take away from today's arguments?
A couple things. One, as you said, it was very, very clear that if there's a principled distinction between allowing people to opt out of public accommodation laws because they don't like same-sex marriage, I couldn't hear a principled distinction between that and people who don't like interracial marriage, who don't like adoption, who don't like all sorts of things. I think the answer to that question each time it was posed was some version of, well, but that would be racist, which is not, in fact, a principled answer. The other thing that was really striking today, Stephanie, was this sort of levity at the court. There was just a whole bunch of silliness, kind of dumb hypotheticals, really kind of rollicking good times, talking about Ashley Madison and Black Santas. And the sense that some of the justices were not taking this as a serious, dignitary challenge to millions of Americans was really upsetting.
I want to actually share a bit of that. This is an exchange between the Justices Alito and Kagan and Colorado's Solicitor General, who is defending the state's anti-discrimination law. Listen to this.
If there's a Black Santa at the other end of the mall and he doesn't want to have his picture taken with a child who's dressed up in a Ku Klux Klan outfit, that Black Santa has to do that?
No, because Ku Klux Klan outfits are not protected characteristics under public accommodation laws.
And presumably that would be the same Ku Klux Klan outfit, regardless whether the child was black or white or any other characteristic.
Yeah, you do see a lot of black children in Ku Klux Klan outfits, right? All the time.
I don't even know what to say about that. He was making some sort of point, I guess, but isn't there a lot more at stake here?
I mean, I think, to be fair, the Supreme Court argues by analogy. They argue by hypothetical. In some sense, goofy hypotheticals are, the coin of the realm. But it's really important to understand in this case, Lorie Smith actually has never designed a website for an opposite-sex couple or a same-sex couple. She's never been forced to say, I deny service to you. This entire case is hypothetical. It's predicated on her argument that I want to get into the marriage website business, and I want to be able to deny service, and I'm afraid I'm going to get tagged for it. So part of what you're seeing here with the kind of goofiness and the levity and the sort of freewheeling, who's on first hypotheticals is that there's no facts. There's no record in this case. There's nothing. And so what rushes into the void in some sense is, first of all, a lot of goofiness, as I said, but also just absolutely no regard on the part of some of the justices for the real humiliation, for the dignitary harms that are going to be faced by real people going forward. That to me was really striking because it didn't have to be that way. You can take the same case on the merits without disrespecting people who have interests in the outcome.
The Supreme Court hearing a case with a woman who runs a business she hasn't even started yet. Talk to us about the other case that we're going to hear about this week. This one's all about elections.
Yeah, this one is a case that is simultaneously the most serious case, in some sense, in terms of election law of my lifetime. It's also the most fundamentally unserious case because it's a really wackadoo theory called the independent state legislature doctrine, and doctrine really belongs in quotation marks. It was hatched in an underground lab. It has no footing in history. It has no footing in existing doctrine. But it is a challenge, a North Carolina challenge, that essentially is making the claim that state Supreme Courts have no power to review state legislatures on election-related operations that state legislatures put into place. This is so plucked out of thin air, and yet we've already seen 4 justices on the current court evince interest in it. And I guess I'm trying to not sound Chicken Little-ish, but the outcome of this case could really quite seriously be that state legislatures have plenary, unreviewable power to do with election law what they want.
Well, Dahlia Lithwick delivering you tonight's Monday Nightmare. Always good to see you. Thank you for joining us tonight.